In the years following Marbury versus Madison, the Supreme Court established itself as a co-equal branch of government. The court eventually got a new, larger courtroom, which reflected its newfound prestige, but there were still questions about the direction of the new republic and a debate about how to balance the power of the national government with the rights of the states. Both sides agreed the Constitution granted some specific powers to Congress. The list of powers is found in Article 1, Section 8 of the Constitution, and they're known as enumerated powers.
That term is just a fancy word for listed. And there are 17 powers listed out by numeral in Article 1, Section 8, 1 through 17. And they cover, everything from taxing, spending, borrowing, regulating commerce, maintaining an army, copyright, post offices. It's a fairly lengthy list. And then number 18 in that section is the necessary and proper clause.
The last item on the list of enumerated powers gives Congress the authority to make all laws which shall be necessary and proper for carrying into execution all foregoing powers. This is commonly known as the necessary and proper clause. And it was at the center of the next great landmark Supreme Court case, McCulloch versus Maryland. In 1791, Secretary of State Alexander Hamilton urged Congress to charter a national bank. There was disagreement over whether or not the Constitution gave Congress the power to do such a thing, since nowhere in the list of enumerated powers did it say anything about creating a bank. But Hamilton insisted the necessary and proper clause allowed it.
The classic articulation of the two constitutional sides of the Bank of the United States come from Hamilton and Jefferson in the first Washington administration. Hamilton's position on that clause is that necessary means the national government has the power to do all things which are useful and convenient. Jefferson's position was the word necessary means vital and crucial. Hamilton's interpretation of necessary, useful, and convenient broadens the power of the national government and would be supportive of having a national bank. Jefferson's definition of vital and crucial narrows the power of the federal government. And Jefferson said it's not vital to have a national bank. We don't have one now, and we still exist. Hamilton says it would be useful to have one to grow the nation.
The charter for the first Bank of the United States expired in 1811. But the War of 1812 created financial trouble for the U.S., and soon Congress issued a new charter for the second Bank of the United States. But the idea of a national bank remained a controversial issue.
Many, particularly at the state level, opposed it because they believed it violated the Constitution for the federal government to institute a bank. A second reason why the national bank was unpopular is because, like any other business, it was in competition with other banks, including banks that had been chartered by the states.
It was also very unpopular because of its lending practices. Initially, it engaged in fairly generous, one would say too generous, lending practices. Another recession came on. It tightened up credit. A lot of businesses and farms and creditors failed because of the new tightened credit policies. And so the bank was blamed for a lot of financial misery, probably accurately.
You also have to go back in the context of the time and realize that the federal government was very new back then. And there was a great deal of fear that the federal government was going to become this tyrannical monster, somewhat akin to the king in England that they had come away from.
The state of Maryland was one of those states where the national bank was unpopular. Actually, unpopular is an understatement. Maryland was downright hostile to the bank. State lawmakers wanted to make it impossible for the national bank to survive.
The state of Maryland passed a law which imposed a special tax on all banks doing business in the state of Maryland that had not received a charter or franchise from the state of Maryland.
And what it did is it said that any bank cannot issue what they called banknotes without a stamp on it that showed that they had paid the state of Maryland $15,000 in order to issue banknotes. But Maryland said Maryland banks, state banks, didn't have to pay that $15,000. And that meant the only bank in Maryland that had to pay that was the Bank of the United States.
This made it more expensive for the National Bank to operate, and the hope was that if it was more expensive for the National Bank to operate, it would just pack up its bags and leave.
James McCulloch was the cashier of the Baltimore branch of the Second Bank of the United States. McCulloch refused to pay the tax, claiming the state of Maryland had no right to tax an entity of the federal government. Needless to say, the state of Maryland disagreed, so they sued.
And of course, the Maryland courts decide for Maryland that yes, of course we can tax the National Bank. We can tax anything we want to. We have the power under the 10th Amendment to tax.
When the case finally reached the Supreme Court, it was clear there was going to be a showdown. Were state governments superior, or was it the federal government that was supreme? Did a state have the power to tax an entity of the national government? And did Congress even have the power to create a national bank in the first place?
The court's argument in regard to the first question of whether or not Congress has the authority to establish a bank really tracks the argument that Alexander Hamilton made during the Washington administration. And that is, the court argues that although there's no specific grant to Congress in Article 1, Section A to establish a national bank, that the necessary and proper clause at the end of Article 1, Section A gives Congress the authority to establish institutions which will carry out the specific powers that Congress, in fact, is granted.
The argument in McCulloch then became Maryland saying, well, yes, there's a necessary and proper clause, but that just means absolutely necessary, critical, vital. You can't do without it. And John Marshall rejected that position and said, oh, no. That was not the meaning of necessary that was intended by the drafters of the Constitution. What they meant was just useful to get something done.
If Congress has the power to tax, well, it ought to be able to have a place where it can put the money, a bank. If it has the power to spend, well, it has to have a place where it can get the money from, a bank. If it has the power to supply an army and navy, it has to be able to move money around the country. Wouldn't it be nice to have a national banking system?
And he went on to say, when we gave the federal government power by drafting and ratifying the Constitution, we could not possibly have anticipated every single thing that the federal government would need to do. So when we did that and we gave Congress and the federal government particular powers, along with those went some implied powers.
And what the necessary and proper clause does is it serves to clarify or to declare that principle. It serves, in other words, to say, just in case y'all don't get this, just in case you don't understand what should be obvious to the average intelligent person, we're going to make it clear in the Constitution that Congress has the power to make all laws which shall be necessary and proper, otherwise, or stated otherwise, convenient, helpful, expedient, to carry into execution all of the other powers that the Constitution expressly gives to Congress.
The court ruled that there were implied powers in the Constitution, found in the Necessary and Proper Clause, which allowed Congress to charter a national bank. Marshall's interpretation of the Necessary and Proper Clause was the same as Alexander Hamilton's had been. Congress had limited powers, and those limits were not to be violated. But Marshall argued that Congress must have the means to carry out the power it did have. So, he devised a kind of test that could be applied to determine if an act of Congress fit within the Necessary and Proper Clause. First, was the act of Congress within the letter and spirit of the Constitution? Second, was it designed to help Congress carry out one of its enumerated powers? If the answer to both of these questions was yes, then that act would be valid under the Necessary and Proper Clause. Justice Marshall, when explaining the court's opinion, simply wrote,
"Let the end be legitimate. Let it be within the scope of the Constitution."
Let the end be legitimate is a reference to, is there a power in the Constitution? And does the law not in any other way violates some other part of the Constitution.
And so it was sort of a reasonable person test. Would a reasonable person think that if the Congress, for example, has the right to build roads, is it necessary and proper that Congress should also be given the right to make contracts with the producers of cement to put on the roads? So even though in the list in Section 8, there's nowhere that says Congress can make contracts with cement producers, it's a logical, reasonable statement that if Congress is allowed to build national roads in the Constitution, the Congress should be allowed to contract with those who can build the roads, even though not mentioned. So Marshall put that kind of limit on the necessary and proper clause.
But what about the question of whether or not Maryland had a right to tax the national bank? To answer this question, the court relied on Article 6, Clause 2 in the Constitution, commonly known as the Supremacy Clause.
Article 6 of the Constitution says that the Constitution and all laws passed pursuant to it are the supreme law of the land. Marshall says if Congress has the power to create a bank, that is national policy and no state can contravene it. No state can try to contradict it.
The Supreme Court said, through Justice Marshall famously, the power to tax is the power to destroy. Marshall said that the state, by trying to tax and thereby threatening to destroy a constitutionally established bank, Maryland was attempting to place itself over the federal government, in this case, the federal government's lawful constitutional bank.
Maryland claimed the Constitution was the product of an agreement by the states, but Chief Justice Marshall disagreed. Marshall said the Constitution had been established by the people, not the states. And since the Constitution came from the people, the states had to abide by it. The Constitution, he said, was
emphatically and truly a government of the people. In form and in substance, it emanates from them.
Using this reasoning, the court rejected the idea that a state could tax an entity of the federal government, and the court ruled Maryland's law was unconstitutional.
We are unanimously of opinion that the law passed by the legislature of Maryland imposing a tax on the Bank of the United States is unconstitutional and void.
Today, McCulloch versus Maryland is referred to by professors, judges, attorneys, and lawmakers as the classic example of the necessary and proper clause. In fact, Chief Justice Marshall predicted that the debate over the extent of Congress's powers would continue well into the future.
The question respecting the extent of the powers actually granted is perpetually arising and will probably continue to arise so long as our system shall exist.
McCulloch versus Maryland was a landmark case involving a battle over a bank. And it wouldn't be long before the Supreme Court would find itself on yet another legal battleground, this one involving boats.